All right, everyone, thanks and welcome for attending today. We have a course for you on SEC and PCAOB developments that are ongoing right now. Welcome. We wanted to take this opportunity because we have Eugene Goldman here, who's Senior Counsel at McDermott, Will, and Emery. Eugene is U.S. counsel that we've used for relevant SEC matters, and we thought he was perfectly placed to provide us some insight to the future about what's happening post the U.S. election. There's a lot of Canadian news, and we're interested in what's going to happen with the SEC and PCAOB, and Eugene is perfectly positioned to deliver that information. So I'll pass it off to Eugene. Thanks so much.
Craig, thank you. We appreciate our relationship and the fact that Davidson today is celebrating its 40th anniversary, I think is a testament to its growth and resiliency. It's not easy in the world of accounting firms to have that record and longevity. I think we could all agree that the Securities and Exchange Commission can have a significant impact on the capital markets and investor protection. Fostering capital formation and securities law enforcement is something conservatives and progressives can agree on and have agreed on. I remember back at my time at the SEC, we had a very conservative commissioner from Utah. His name was John Evans. He came to Washington with Senator Bennett, one of the most conservative senators in the United States Senate at the time. And he was appointed to the SEC. And he brought with him conservative principles that the capital markets require enforcement to foster investor protection. Because without enforcement, investors may lose confidence in the capital markets, and that in turn may hurt and would hurt capital formation. So he, in effect, was aligned with the renegades like myself in the Division of Enforcement, and it was a very good relationship, and it just shows you the historically that the SEC has been treated favorably on a bipartisan basis. So what is the state of the play today? So here is the commission as we see it at the moment. Chairman Gensler, the Biden chairman, is resigning on Inauguration Day. Okay? And another Democratic commissioner is resigning shortly before. Now the commission consists of 5 commissioners. The majority of the commission is aligned with the party of the president. So there will be 3 Republicans and 2 Democrats, just like there are 3 Democrats and 2 Republicans right now. So when Chairman Gensler resigns, in all likelihood, President Trump will appoint as an interim chairman one of the 2 commissioners, Republican commissioners. And then when the Democrat commissioner resigns, President Trump will nominate a Democrat to the commission, and that would have to go through the confirmation process. Historically, there's deference given to the Democrats on the Senate Banking Committee. We'll see if that's the case here. So we expect some significant changes with a Trump chairman. As you'll note at the bottom of the screen, the SEC has the power to replace the members of the PCAOB board. And in fact, President Trump in his first term proposed folding the PCAOB into the SEC. That didn't go anywhere, but we'll see what happens this time around. Frankly, I had expected the president to have nominated a new chair by the time I joined you today. That appointment is imminent. We await a few days, but there are some predictions I think we can make as to the priorities of the SEC going forward. And you'll see check marks no and check mark yes on these items. So unlikely to have an aggressive agenda, unlikely to seek higher penalties, but continue emphasis on the individuals. The election year dynamic will drive focus on political themes like environmental, social, and corporate governance. Recent rule changes likely will spur additional enforcement. We don't know what the budget's going to look like. Because of advancements in technology, it's easier to detect inside trading. And I think inside trading will remain a priority for this commission. As I mentioned before, I think SEC enforcement efforts historically are relatively bipartisan. The examination and enforcement staff remains relatively constant, and there are investigations that take a long time that are not close to being finished, and they take time to work through the system. Staff will work to enforce existing regulations, such as the newly minted cybersecurity disclosure requirements. Now, cybersecurity also, I think, would enjoy a bipartisan approach. When a company is hacked and there's customer identification information, medical information, trade secrets, things of that nature, it's important that the public companies have the state-of-the-art in protecting its data. And their disclosures about how they're going about that have been watched closely by the SEC. Now, I'll get to an important case in a few minutes. So this, I believe, will remain a focus. But if a company is purely victimized and they had decent controls, I wouldn't expect much scrutiny of their disclosures and potential targets of an enforcement action. Changes are likely to come in the form of emphasis. I think traditionally in Republican commissions, the focus has been on have investors lost money? Are there real wrongdoers? Let's get some of the money back to the defrauded investors, as opposed to bringing cases based on esoteric concepts of disclosure. I think the area where there'll be significant changes in the crypto space. We expect much friendlier SEC when it comes to cryptocurrencies in terms of setting forth some clearer guidelines. Are they securities? Are they not securities? What are the best ways to make the industry, the crypto industry, aware of what the federal government is expecting? And that can be done through additional regulation. The CFTC may share space with the SEC in this area. And I know the crypto industry is very excited about the change because they have viewed Gensler as not a friend of the crypto industry. But everyone is still aware that there have been true frauds growing out of the crypto space. But that's different from providing some certainty to the industry which they deserve in terms of what they can and cannot do. So here are some stats. If you compare the number of enforcement actions brought under the Trump chairman compared to Biden, it's pretty close. But I think there's a reason for that. And the reason is that the Trump chairman was Jay Clayton, very familiar with the industry. He was a believer in the SEC. He was a believer in the rule of law and enforced it. And I think in the world of Trump appointees, he was very well regarded. President Trump has now nominated him to be the United States Attorney for the Southern District of New York, right in the heart of Wall Street. I think he'll have a good confirmation, very well respected. And we'll see whether the appointment will resemble Jay Clayton or someone who has a totally different point of view. If it's a totally different point of view, then these numbers would in all likelihood go down. But the 467 under Trump should not necessarily be regarded as what's going to happen next with the next Trump chairman. That's my point. I think there'll be a re-emphasis on internal controls. I think some have criticized the Commission for bringing cases that lack more substantive fraud allegations, but rather they advanced policy aims. So you can read the slide for yourself. I think it's pretty clear that there'll be a change of emphasis when it comes to bringing enforcement actions based on internal controls and disclosure controls. ESG regulation and enforcement, I think it's likely we'll see efforts to discourage ESG regulation and enforcement. And a clear target would be the Commission's complex climate reporting regulations, which are currently on hold in the face of a court challenge. I think we can predict a new Trump administration likely would revisit changes in the SEC's approach to proxy proposals. In recent years, the Commission restricted the ability of public companies to refuse to include shareholder proposals that focused on social policy agendas. Overall, I think we could look to the Trump administration to focus on expanding access to capital markets for large and small companies. It's likely that the new SEC administration would support this agenda. For example, one of the Republican commissioners recently spoke about simplifying securities regulation exemptions. So with less regulations, I think that will encourage more deal making, more mergers and acquisitions, because you have a parallel lack of enforcement on the antitrust side. That combined with relaxed rules in terms of disclosures on the capital formation side at the SEC, the net result will be, I think, more deals, more transactions. Cybersecurity, I mentioned before. There are new disclosure rules in place in terms of disclosing a material incident in the current report of the public company, the 8K, as well as in annual disclosures. In October, the SEC brought in action on the same day against 4 companies. They were basically technology and communication companies, and they, without knowing it, they installed a malware that belonged to the Russians, it looks in all likelihood, and it was part of the cyber attack on SolarWinds. So these are basically downstream victims of the Russian cyber attack on SolarWinds. And these companies unknowingly installed the malware. And the Commission believed that these companies either negligently minimized the risk of a cyber attack, were slow to disclose what they knew and when. The 2 commissioners, the Republican commissioners, dissented. They said, look, these companies were victims, and we didn't think the so-called disclosure violations were material. I think when you look at this, I think the dissents of the Republican commissioners could in effect be a proxy for how a Republican-dominated commission will run things. So these are signals from the dissenters who are now in a minority. I think when they become part of the majority, you'll see their philosophy, their emphasis take place. So in this case, they had dissented in these cybersecurity cases. Insider trading. I mentioned before that we now have a consolidated audit trail. This allows regulators to trace all orders and trading activities in the United States markets. So the technology, light years ahead from when I was at the SEC, and we did a lot of insider trading when I was at the SEC. We had some big cases, but now people really are not aware that when they have material inside information and trade on it, they seem to think, well, they'll never find out. They'll not make the connection with my neighbor down the street. That's not the case. There are some very sophisticated mechanisms to detect insider trading. FINRA, the regulator of the brokerage industry, basically sends out questionnaires in situations when there's a spike in trading activity shortly before a merger announcement. And then the stock price goes up after the announcement. So they go back and look at who actually traded in the week before. And they get a list of names. And they send a list of names to the company. And they ask them, please identify anyone on this list that you're familiar with. And you get hits from that. Oh, this is the son-in-law of, or controller, or things of that nature. But here, we're now in a new world with this consolidated audit trail that I think makes it easier for the regulators to detect inside trading. That will remain a priority. I remember I was at the commission during the Reagan administration. I remember the Reagan chairman who came out of Merrill Lynch said, we're going to use hobnail boots. That was his language to get at inside trading, and that hasn't stopped. A lot of it is done globally, overseas. The U.S. has bilateral and unilateral arrangements with their colleagues overseas who are also regulators in their countries to share data. And it used to be that if you traded through a Swiss account, you were safe. That's no longer the case. Accounting and disclosure investigations. We expect continued enforcement efforts around revenue recognition and financial statement fraud, as well as focus on individual liability. We think the staff will continue to examine non-GAAP metrics. And sweeps are likely to continue. What are sweeps? Sweeps is when the commission detects a problem that may be systemic within a particular industry or segment of an industry. So what they do is they send questionnaires to companies that are within that segment of the industry. And they ask them to fill out answers to these questions to see if they could sweep other companies in the same manner that they have found clear violations from one company. Now, these sweeps are very expensive. The recipients of these requests are normally just innocent companies that just happen to be in the same industry as the company that has made violations. But we would expect sweeps to continue. I think their review would be carefully done with more scrutiny and not launched except from a centralized place with the enforcement division. So you wouldn't have a regional office in Miami making its own decision to send out 45 letters to 45 companies all over the country asking them to respond. The gatekeepers. Let's talk about audit committee members and obligations. This Cubient case, where the SEC sued the audit committee chair and the chief financial officer. So what happened here, I think it's worth taking a minute to review. the public company allegedly fraudulently inflated their revenue. In fact, the product involved with that company did not work, and the CEO fabricated fraud analysis, recognizing over $1.3 million in revenue. The audit committee chair was allegedly informed that customer data had not been analyzed for fraud and the company may need to restate. But instead of investigating, the chairman of the audit committee perpetuated the scheme, allegedly, by making false statements and lying to the auditors. And the quote from the commission, "This case should send an important signal to gatekeepers like CFOs and audit committee members that the SEC and the investing public expect responsible behavior when critical issues are brought to their attention." Again, this is an unusual case in that we don't often see the chairman of the audit committee helping the company hide the fraud, as set forth in the complaint by the SEC. This is a litigated action. It's not settled. Most cases brought by the SEC are settled. This one's litigated. It'll be watched carefully to see what the two defendants have to say for themselves. But the SEC is reminding people that they view the audit committee as an important gatekeeper to oversee the compliance of the company with the securities laws. Let's talk about independence of audit committee members. Again, pretty unusual case. This is against an individual director based on the unusually close relationship between the director, who was disclosed as independent based on the questionnaire that he filled out, and a high-ranking executive. They took regular vacations with their spouses, domestically and internationally. The director paid more than $100,000 for the executive and spouse. And the next bullet is telling, in my view, because it suggests intent. Advise the executive not to tell anyone about their relationship. And they shared information about a sensitive CEO search process. This case was settled. They were personally fined $175,000 and barred for 5 years. So what we're suggesting to our clients is take a good look at the questionnaire that's filled out and is sent to directors, and see if you're covering all kinds of potentially and meaningfully close relationships between directors and senior management. And you may have some responses that would require follow-up. Whistleblower protection, been a very active area of SEC enforcement. There's a rule that basically says that no person, whether it's a public company, an auditing firm, anybody else, you can't impede an individual from going to the commission and telling the SEC about a possible securities law violation, including by enforcing or threatening to enforce a confidentiality agreement with respect to such communications. The SEC looks to protect the ability of an employee or other individual to report confidentially and to benefit from reporting. The key point here is that the staff has taken the position that no actual interference is required, which is arguably inconsistent with the rule's language. Again, let's go back to the rule. No person may take action to impede an individual from communicating, including enforcing or threatening to enforce a confidentiality agreement. So we're recommending that companies review language in their employment and severance agreements. We're likely to see less emphasis and lower penalties in the new administration, but still an area of focus for investment advisors and for public companies. And obviously be careful of actually interfering. So let's give some examples of what the SEC has been concerned about. You may have departure agreements, separation agreements, severance agreements that say you cannot disclose any confidential information to the government if required by law or court order. So if you're a potential whistleblower and you have some information you'd like to share with the authorities, you're not required by law or court order to do so, but having this clause in your employment agreement, severance agreement, would suggest that, well, I better not do that because I'm not required by law or court order to disclose the confidential information. Also, the SEC has seen provisions in these types of agreements that prohibit the employees from receiving any kind of financial award in effect for whistleblowing. And as the person is going out the door, perhaps going to a new job, and they have one of these departure agreements, the SEC has seen the employer, soon to be the former employer, require a representation that that employee has not filed any complaints with anybody. That's a violation in the Commission's view. So let's move to the PCAOB. Some very interesting developments there. I want to spend a few minutes talking about a case. It's called SEC versus Jercasey, United States Supreme Court. You might say, why am I talking about that? It doesn't have the PCAOB in the case. Let me explain. When the SEC decides it has enough to bring an enforcement action, it has a choice. It could seek to bring the action before an administrative law judge. That's an in-house judge at the SEC. Or they could decide to bring a case in federal court. So if they bring a case before an administrative law judge, you have a hearing, you have decisions by the administrative law judge. If you don't like the result, you get to appeal. Gets to whom? To the commission itself, who authorized the case in the first place. And then from there to the Circuit Court of Appeals. Okay, so the SEC has a choice, federal court or administrative proceedings. When they decided to go administrative proceedings and seek penalties, they were authorized by statute to do that. SEC Jercasey says if the SEC seeks penalties, the person has a right to a jury trial on that issue. Seventh Amendment, right to jury. So when the SEC seeks penalties, the person must be given a right to challenge that effort in federal court. So you won't be seeing penalties before administrative law judges unless they're agreed to by consent. The PCAOB, there's no clear mechanism for the PCAOB to seek penalties in federal court. They have something similar to an administrative law judge. It's called a hearing officer. So you get to contest the PCAOB. They may say the auditor negligently or recklessly failed fell down on the audit, on performing required procedures, applying GAAP, you can name it. So that is contested before a hearing officer. And as a lot of us know, the PCAOB regularly seeks fines in appropriate cases against the auditing firm and individual auditors. So they may be stuck here because the argument will be made, this is, like an official proceeding. It has enough governmental authority under Sarbanes-Oxley for the PCAOB to operate. The board's appointed by the SEC, which is appointed by the president, so there's authority there. So it has already been argued, and it's currently litigated, that the PCAOB cannot seek penalties before the hearing officer. So what happens? If there's no clear statutory authority for the PCAOB to go to federal court, are they out of luck? What will they do? If that happens, what they may do is refer the case to the SEC and let the SEC take it up and let them go to federal court to seek a penalty. But for the PCAOB itself, it's an issue. It could be a real problem. Related to that is when the PCAOB seeks suspension or bar, keep the auditor out of the profession. In effect, to deny the livelihood of that auditor. And arguments are brewing that is similar to a penalty. You're depriving me of my livelihood. And the battle will be whether that's remedial action by the regulator or punitive act against the auditor. Is remedial to help cleanse the audit from bad actors? So that is also brewing. But aside from that, let's take a look at some of the trends in PCAOB enforcement. And a lot of this can change, because as I mentioned, the Trump Commission in all likelihood will replace the current PCAOB board. So these trends that are based on cases to date, may not be, may not continue. And these are, filing violations. And let me go back to Jarcasi again. I think Jarcasi is a problem for the PCAOB when the PCAOB is alleging falling down in the performance of procedures and audits. Jarcasi may not help you if we're talking about what I call a regulatory infraction, not filing a report, or auditor independence, which is just a clear rule, may not involve negligence, for example, or specific knowing wrongdoing. So that may be on hold. But here are the trends. So in this first case, KKM, they failed to identify an audit engagement in its Form 2. $25,000 fine. L&L CPAs failed to identify 2 reportable events on a Form 3. Form 3, as we know, you have to disclose disciplinary proceedings pending, final, or otherwise within a certain matter of time. You have to put that information on a Form 3. And through PCAOB's monitoring of Form 3 compliance, that's how this was found out, $20,000 fine. Both the SEC and the PCAOB, in the Markham case, in the Witham-Smith-Brown case, they focused on staffing and workload. So in Markham and Witham, the firms accepted hundreds of new issuer clients without determining whether they had sufficient capacity to accept such clients, resulting in manager workloads, partner workloads, utilization rates went from 112,000 to 220,000 during the busy season. Repeated documentation and Form AP failures. APs are where you identify the engagement partner on the audit. Failures to perform risk assessment procedures and consult on complex issues. Big penalties here. PCAOB on the one hand, $3 million. SEC on the other, $10 million. Impose an independent consultant and the required changes to the firm's supervisory structure. Lithium, a $2 million penalty, and had to employ an independent consultant. A few more. DeVista Gray LLP. The deficiencies here were identified in the 2019 PCAOB inspection, and they were repeatedly found in the 2021 inspection. Critical audit matter procedures were flagged. Pre-approval requirements before providing tax services. As you know, if you're doing non-audit services, you need the blessings of the audit committee before you engage in the activities. Required audit committee communications. There are standards where the audit committee has to communicate. The auditors and the audit committee have to communicate with each other. It's a burden and standard put on the auditor. A late form of APs, Form APs, and $60,000 fine for QC violations. Next one involved repeated QC deficiencies. Malone Bailey case, $400,000 fine, independent consultant required. And you'll notice that a lot of these infractions are found through the inspection process. And we see more and more inspection referrals to enforcement. And sometimes a company, sometimes an auditing firm just gets a proposed settlement in the mail from the PCAOB. Would you like to settle? This was found out in an inspection. We think it's a violation. It should be enforcement action. So without a phone call, you just get something in the mail. That has happened. And so that's my point is there's sometimes a close connection between the results of an inspection report and going directly to enforcement of the PCAOB. And here's some others having to do with not fulfilling the requirements to communicate to the audit committee about various things. We have some Canadian firms on here that you'll see. $30,000 penalties for, again, these are communication issues between the audit committee and the auditor. Some would say this is like low-hanging fruit and tough on smaller firms who have to face this, but perhaps some of that will change. I can understand the PCAOB's message. They want to send a message that they have these rules, they have these disclosures and required communications for a reason. And if you don't obey, you just can't stand pat and think nothing will happen. So in terms of non-monetary sanctions, I should add here that a study just came out last week from Cornerstone Research. The SEC has promoted cooperation. You will benefit if you cooperate with the SEC's investigation. You'll benefit if you self-report violations, if you assist us in digging out what happened and then reporting the results to us. And there have been more non-monetary settlements from companies who have cooperated with the SEC than ever before. More last year than in the last 10 years. In any year within the last decade, I should say. So I think that's about it. Craig, you have any questions? Any questions from anybody?
I guess I've got one, I guess.
Okay.
For PCAOB, so when Trump was talking about rolling PCAOB into SEC, did he provide reasons why? Like, what are the explicit reasons that he was thinking about doing that?
The SEC is empowered to bring those cases, and I think it was seen as a duplication of effort. The SEC is equipped. If you bring people over from the PCAOB, and make, as long as the staffing is commensurate with the job that needs to be done, why have that extra layer of bureaucracy? But if you do that, you're also going to have to incorporate the inspection program within the SEC. SEC right now conducts examinations of investment advisors. It conducts inspections of broker-dealers. It doesn't have an inspection function of auditors. The PCAOB does that. And the Democratic Congress, and particularly the Senate, I should say, wasn't overly enamored with the idea. I think some thought that the PCAOB was created as a result of Sarbanes-Oxley. Sarbanes-Oxley was created as a result of one financial fraud, auditing fraud after another, and it was just a required mechanism back then to put the auditing profession on a more compliant plane. And whether President Trump will propose that again, I don't know. I don't know. But unlike the SEC, the PCAOB members are not by Democrats or Republicans. But even so, just like the Trump PCAOB was totally replaced, this one is likely to be as well. And you'll have a different focus. I mean, there's been a lot of discussion that young people no longer want to become accountants. Accountants who've been accountants for quite a while no longer want to be accountants. The regulatory pressures are too much for some, and we'll see what happens.
Who elects the board of the PCAOB?
The SEC.
So isn't that therefore under the SEC anyway? If the SEC is electing the board of PCAOB, then isn't it under the SEC anyway?
They're under the SEC. They need their standards approved by the SEC. They're proposed. They get comment from some of you in the room, but they eventually have to be approved by the SEC. But in terms of carrying out the investigations, those are PCAOB staff members, not SEC staff members. And they're not government employees. So there's oversight, but the day-to-day work, the heavy lifting is done at the PCAOB itself. The setting of their own priorities by the current chair of the PCAOB, along with the board. So they're appointed, but after that, the SEC approves their standards and budget. I think there's some budget differences as well. PCAOB is funded, at least in part, from fees collected from public companies that are audited. So there are changes. There are differences, I should say. Mr. Block.
How do you see the small firms in the future? And it'd be interesting to know, in the last 10 years, how many small firms have got out of public audit? Like in the U.S., you would think that the barriers to entry are so
I don't know if there'll be 10, but I think more will merge with others as opposed to getting out of the business altogether. And there'll probably be more of that. Private equity is now looking at auditing firms as acquisition, potential acquisition candidates. So you see that in the industry as well. But for the small firms that don't have large scale, to keep up with the overhead and the demand, I think you'll probably see some more consolidation. But again, one of the issues is it has been demonstrated in the last couple of years that it's tough to get accountants, young people involved and interested in the business, and that's a problem. And I've seen very good auditors over the years, individual auditors, who have no enforcement problems, but they're on the file of a file that's under inspection, and they come out of the inspection, rattled, discouraged, and they want to move to a different part of the auditing firm, maybe tax or consulting or something like that. So I think that has to be a sensitive issue on the table for the next PCAOB.
Can I ask you make 2 more predictions? For one, I know we got a lot of companies here are interested in kind of SOX 404 requirements and potentially getting relief under them, whether it's from definitions of being an accelerated filer, a large accelerated filer, or under the Jobs Act, whether there's going to be kind of more relief coming for companies that wouldn't be barred there, and then whether there'd be anything as far as, there'll be lots of changes from a tax perspective, but if there's anything specific that you expect for the IRS.
Don't know about the IRS, and just in general, I think in the 404 world, that will be on the table for review. That will be on the table for review. I mentioned efforts to increase capital formation, maybe by lessening the standard for an accredited investor. I think on the regulatory side, all that is on the table. Glenn?
Hi, one last question.
Okay.
So
Oh, sure.
Silicon Valley basically bankrolled Trump's election. What do you think the biggest thing that Silicon Valley is going to push Trump to push in?
I'm sorry, could you repeat the question?
So Silicon Valley basically bankrolled Trump's election, like Elon Musk had $200 million and a lot of other ones. What do you think the Silicon Valley is going to be the biggest push
I think
Trump to do?
I think within Silicon, we're talking about cryptocurrencies.
I'm talking in just general.
Yeah, but in the crypto space, the crypto industry was very, very involved in the election. Large contributions, and I think what they want is a chairman who is sensitive to the need for clearer guidelines for the crypto offerings. And what can I do, what can I not do? And from all the people on the list of potential appointees, they're certainly all more sympathetic than Mr. Gensler is to the crypto industry. So the biggest result for them from the election would be a new chair. And the Republicans on the commission right now are certainly friendlier to crypto than the Democrats on the commission. Other than that, I'm not sure. I think they're more interested in loosening of things that would make M&A and similar transactions go forward.
Do you see a potential of a federal crypto fund?
A what?
Do you see the potential of a federal crypto fund?
What kind of fund?
A federal one?
A federal one? That I don't know. But we are seeing larger and larger investment firms accepting crypto as an asset that's available to be offered to their clients. Glenn, do you have a question?
No.
Okay. All right.
What about antitrust stuff? I saw some news about Google getting broken up, but
We do a lot of antitrust work at the firm, but I don't do it, so I couldn't comment on it.
anything for, I mean, you know, Trump in general is very into kind of protectionist kind of movements. You know, there's in Canada we have a lot of foreign reporting issuers. You know, Canadian firms that are operating in the U.S. Do you expect any changes to regulations in that space?
Not that I know of, no. As I mentioned before, the United States, through the SEC and others, have bilateral and unilateral agreements with other countries to share information and, in effect, have a global enforcement mechanism to combat fraud. They have a specialized crypto effort going on the last year or so, because it's clear that you know, fraud does not stop at our borders. There's internationalized fraud in effect. So there's an organization called IOSCO, which is basically an international organization, securities regulators around the world. And what I call a soft treaty. They don't have a treaty that's enforceable by law, but by agreement. And if the SEC wants to see someone in England, for example, and that person says, no, I'm not interested in talking to you, under this agreement, just as an example, the SEC can go to the Financial Conduct Authority, the equivalent of the SEC in the UK, and the FCA can compel its own subject to come to a meeting with the SEC in London. One of the things I'd like to do in my representation of clients is assist foreign auditors and others to get ready for the visits of the SEC when they come over, technically under the auspices of the foreign regulator. But what happens is the foreign regulator in the interview says, this is under the auspices of the FCA, and we're here, you know, with so-and-so and so-so from the SEC, and you are here, you know, to answer their questions. Then they go off in the corner and read the newspaper for the next 3 days, and all the questioning is by the SEC. So we have those agreements, and we provide that also. So if Spain is looking for a securities defrauder hiding out in the United States somewhere, the SEC could compel that person to cooperate with his country's regulators. I don't think that will change under the Trump administration. The first solid agreement in the inside trading space, where people were hiding out in Switzerland, trading through Swiss bank accounts and, you know, hidden names, the breakthrough happened under the Reagan administration. And where the Swiss law was changed to clearly make it illegal under Swiss law to commit inside trading. It wasn't that way before. And once that law was changed, they were then able to say, we will help our colleagues in other countries enforce their inside trading laws. So that was a big effort by Reagan. So in this area, I don't think much of that will change. How about you? What's your question?
How about regulation in China? Do you see more or less? There probably would be more with respect to, they're already stacking up, but the regulation appears to be significantly less than the United States.
I don't know how they're regulating their own. I know in the auditing world, our regulators have been pretty insistent that for a Chinese auditor auditing the financial statements of a U.S. issuer, you got to let the PCAOB in on inspection. And they have said no for years. And there were some enforcement actions. There was a threat of not allowing companies to list in the United States if their auditor was not allowing the PCAOB to come in and look at their books. So China backed off a little bit. So I think we'll still, we'll see more of that. They're very protective of financial records, China-based records, things of that nature. But other than that, domestically, I would not be familiar with how China would soften or strengthen its own regulations.
That's great. Well, thank you, Eugene,
Okay.
for coming out. This was great, and we'll get gathered this time next year and see how you did as far as.
Who's going to win the Super Bowl?
Okay. It's good being with you. Thank you very much.
Thanks so much.
Bye-bye.